Hi, everyone. I think we are still having a few more people join us this morning. We're excited that you're all here. Appreciate you coming. I am Kathy Borders. I am in Provider Relations here for Butler County. We also have Amy Winkler on the call with us from Provider Relations as well. She'll be helping to man our chat today. Just a couple of things to make you aware of. We just ask that you stand mute while everyone is speaking. If you have a question, we love questions. We love to hear from you, and we'll do our best to try and address those things that you have questions about. We'll have some time for that at the end, and then also while our presenter is speaking, we'll have time afterwards to ask questions as well. But we encourage you to use the chat feature down at the bottom of your screen. Feel free to drop in any comments or questions that you have there. And we'll do our best to get those answered either in the meeting. And if we're not able to in the meeting, we will definitely get back to you and get those answers for you. All right. Guess we'll go ahead and get started. I'm looking for my first guest. We have our Community Connections team joining us this morning. I will turn the time over to Cassie Matea for if she is here.
Hello. Hi, everyone. Good morning. Thanks for having me. I really appreciate it. Won't take up too much of your time as we do have a lot going on over in the Community Connections department, but some of it is coming out in the newsletter today, so I'll leave that to your guys' imagination. But that is one thing I do want to talk about. If any of you aren't currently on our Community Connections newsletter, you can email me or you can get on our website and subscribe. It has a lot of great events, a lot of opportunities for different trainings. We have donation requests in there. We also have featured stories that we've just done. So it's a really, really neat newsletter. And like I said, for providers especially, I think it would be great to share with those you serve. So if anybody needs that, I actually will put my email in the chat, butlerdd.org. Awesome. All right. Yeah. And like I said, you don't have to go to the website if you don't want. You can just email me and I can put you on the list. It does come out today at noon, which brings me to my second topic. We have two pretty important donation requests right now that I kind of wanted to, let you guys know about. So currently we're having a lot of scenarios where someone that we support is in need of basic goods like groceries and gas. So we are looking for donations of gift cards to Walmart and Kroger to fill this need. Any amount is helpful, but typically we prefer donations of 25 or 50. If you guys would like to donate, please deliver or mail the gift cards to Butler County Board of Developmental Disabilities. And I will put that in the chat too, because it's going to be to our Community Connections Coordinator, Ginny Mann. So if you guys want to donate, I will put that in there. Our second donation is we need an extra long twin bed frame and mattress. That's another thing that we're looking for. So I will actually drop Ginny's email in there. Sorry to bombard you with all this info, but I feel like it'd be easier to put it in the chat. And that is her email. So if you have any questions, please let me know. And then lastly is one of my most important topics here is I typically do a DSP of the month every single month. I think it's really important to recognize those DSPs that are going above and beyond. As of recent, I've had a little bit of trouble of getting nominations, I think mainly because this is the busy season for a lot of people. But I would like to get some more donations in. I did reach out to a lot of our departments recently and got quite a few. But of course, I'm always looking for more more nominations. So basically, if you know somebody that's a DSP that maybe necessarily isn't just doing their job description, they're going above and beyond, maybe outside of work, maybe in the community, maybe they have started something, an organization or some type of group. outside of their job description, I would love to hear about it. So I'm going to drop the link on how you nominate somebody. Basically, all you have to do is put your name, your email, their email, and then why do you want to nominate them? What are they doing that's, you know, going above and beyond? So I'm going to go ahead and put that link in there real quick. That way you guys have it.
The guy with me.
Let's see here. Alrighty. Put that in there. And like I said, it doesn't have to be super long. Typically after I select somebody, I will reach out again. And in that case, when you have time, you can give me more information, maybe some photos. I also reach out to the DSP to make sure that they're okay with being recognized, of course, because I know some people go above and beyond, but they don't want people to know about it, which is fine. I'd like to know about it, but yeah, I want to make sure that they feel comfortable. So basically, that's all I got today. We do, of course, always have fun and exciting things going on over here, stories. I'm also looking for graduation photos. Always like to see those. Typically I reach out to, you know, our staff for that, but hey, providers, if you have any grad photos, I'd love to have those. Just make sure that they have a photo release and that they're okay, obviously, with their photo being shared. But other than that, thank you guys so much for having me, and I look forward to hopefully seeing some nominations for some awesome DSPs.
All right, thank you so much, Cassie. Thanks for coming. We appreciate it. If any questions, feel free to give her an email. She dropped all that in the chat, and I will make sure to include that in our meeting minutes as well, so that you have Cassie's contact information. So thank you. All right, we have our next guest. We're excited to have Christina Gable here from APSI, Ohio. I will go ahead and turn the time over to her to present some information to us about guardianship.
Sure, thanks for having me. See a number of familiar faces and names on the screen, and some I don't recognize. So for those of you that don't know who I am, I'm going to do a quick introduction of who I am and what APSI is. For those of you that are not familiar, I am Christina Gable. I am the Regional Program Director for our Southwest region of APSI. APSI is a statewide nonprofit organization that provides guardianship for adults with developmental disabilities. We're actually contracted to the state of Ohio to provide these services. And so we operate in all 88 counties in the state of Ohio. So my region, we oversee the lower 16 counties here in Southwest Ohio, or the region that my staff cover. So Butler is involved. So one of the things that we do outside of guardianship too is we also offer technical assistance. So if you guys are running into struggles and trying to brainstorm solutions to issues, you guys are welcome to give myself or Tricia Peckno, our rep supervisor, a call, and we are happy to brainstorm maybe outside the box options that you guys haven't considered in a situation. We get calls all the time, whether it's from family members of loved ones that the courts have referred to us, or providers, or even county board SSAs will sometimes give us a call, or county board representatives will give us a call and just kind of pick our brain on, you know, resources that are available, or, you know, situations that maybe we come across these things before. It's always just a great sounding board. We also are really embracing supported decision-making and targeted decision-making on our end. And I'm going to be talking about that a little bit more as further on, but I wanted to highlight that that's another area that APSI is really trying to venture into, because it's a less restrictive option than guardianship. So one of the things that I wanted to kind of discuss with you is about guardianship as a whole. One of the questions that we frequently get asked on our end is who needs a guardian? You know, and how you go about getting a guardian are some of the main questions. The who needs a guardian is very much subjective. Ultimately, it's going to come down to whether or not a physician feels that an individual lacks the capacity to give informed consent on decisions in their life, and whether or not a judge agrees with that and decides a guardian is needed. However, some of the areas that are most commonly reflected in the individuals that need guardians are situations in which, how do I want to put it? an individual maybe has more profound issues, really does not understand situations where informed consent is needed, and or they are making extremely poor decisions that are jeopardizing their health and safety, and they don't understand the consequences of them. It's very different than situations where an individual does understand the consequences of their actions, but doesn't care. I wanted to highlight the difference there because a guardian is great. We do great work. We are in place for reasons to help our individuals advocate for their wants and their needs and make sure they're healthy and safe. That being said, we cannot enforce an individual decisions to change. We cannot make them cooperate on services. And that is not only something that I think other people struggle within the system to understand, but it's also something that judges themselves fail to understand. I myself have sat in front of many judges who have said, well, why can't you force them to take their medication? And I have to say, do you want me to hold them down and force the meds down their throat myself? And then when I point out the absurdity of that, they understand the limitations we have sometimes in situations.
Mm-hmm.
So whether or not a guardianship is needed is something that needs to be discussed, I think, amongst the entire team of an individual service, an individual's entire service team. You guys are the ones that know the individual the best, and you guys are going to be the ones that understand whether or not an individual really truly understands the decisions they're making, or whether or not they're really lacking in the capacity to provide that consent. If you think they're lacking in the capacity to provide consent, is it in all areas of service, or is it just in one? You know, are they really just only not understanding medical, but they can make their own day-to-day decisions when it comes to where they go to work, you know, who they want to work in their house, you know, what they want their ISP goals to be? Do they lack the, you know, do they have the capacity to make those decisions, or, you know, where's that limit? And when you have figured that out, then that's when you kind of want to approach whether it's APSI or Lifespan, any other organization, or a family member of the loved one, or a family friend, about potentially taking over guardianship or seeking guardianship. If you guys are ever not sure in a situation whether or not an individual might warrant guardianship, again, use us for technical assistance. We get these calls all the time on, you know, I have this situation. I really don't know if this warrants guardianship or not, but you know, what are some options here for us? And that is something I am more than happy to talk about to anybody on this call, if that ever should arise when you're raising cases. One thing to be considerate, though, is guardianship is the most restrictive measure you can put in place for an individual, because by putting in guardianship, you are taking away essentially the rights of the individual and putting them into the hands of the guardian themselves. That does not mean that the Bill of Rights does not exist for the clients. It does. In fact, the Supreme Court of Ohio recognizes the Bill of Rights and everything. However, when it comes to the health and safety of the client, the guardian's verdict will always override the individual's wishes in those ways. That being said, a guardian should always take into consideration the individual's wants and wishes and try to accommodate them when they are completely able to do so. And when they can't, in my eyes, best practice is to be open and honest with the individual about where that decision is maybe not going to be supported by them and why, and what they can do differently to have those voices heard in the future, especially if there's a health and safety concern involved. One of the big areas where I often get calls about guardianship is when an individual is involved with criminal cases or criminal situations, law enforcement. I'm going to say this right now. Criminal trumps probate every day of the week. If you have a guardianship under probate court, there's not anything I can do to stop a legal action occurring against an individual in a criminal court. The best I can do is advocate for an individual's to get public representation, to make sure that, you know, if they're held in the jail, that jail knows what medication they're on and hopefully gets the medication they need. Maybe advocate for a competency evaluation if they're facing felony charges. You know, help advocate for, you know, resources and supports while they're going through this process. But unfortunately, I can't stop legal sanctions from happening as a guardian. I also can't get them dropped either. And that's something that I think a lot of individuals really struggle to understand, because if you can be incompetent and need a guardian in a probate court, why can you face criminal charges in the criminal courts? And the answer is pretty simple, in the sense that the different levels of competence, there's two different levels of competency. Probate is looking at whether or not you can make day-to-day decisions, and whether or not you understand informed consent. Criminal court's looking at whether or not you can participate actively in your own legal defense, and that's it. They do not take into account whether or not you can make medical decisions on your own, or whether you can make a decision on what provider works for you. They don't care about that. They want to know, can you meet with the attorney? Can you talk about what the options are? If you can, then great, you are capable of standing trial. And so just because you have a guardian under probate does not mean that you're incompetent to face criminal charges. And we have had numerous individuals end up in prison that have guardianship cases. There are a couple different types of guardianships out there. I want to kind of break it down real briefly for you. I'm not going to go real in depth on the different types. I think it gets really in the weeds here, but I wanted to make you understand that there's a couple different terminologies you're going to hear. Guardian of person is the most common. That's what AFC offers, is guardian of person. Guardian of person is basically over decisions of medical, placement, programming, and behavioral needs of an individual. We have no authority in areas like the right to vote, sexuality of a client, the right to marry, any of that stuff. We have no say at all in it. The other aspect we have no say in is financial. The guardian of person does not have any jurisdiction on anything financial, contracts, or otherwise. So that includes leases. That includes stable accounts. That includes, payee services. We can select a provider of service in those cases, but we can't actually, do anything beyond selecting the provider. So a guardian of estate would be the one that would be over any of those financial matters. If there was big legal financial decisions involving an individual where, usually an attorney is usually the one appointed as a guardian of estate to help come in and settle issues. That being said, most individuals don't have a guardian of estate because they don't have an estate to manage. Typically, you need about $25,000 of assets or a significant issue in which something needs to be settled. Most commonly, where we have a guardian of estate appointed temporarily in cases where we are involved is when a loved one's family member passes away, and part of the will process, assets may be left to them. And so we'll approach the probate court to appoint a temporary guardian of estate to just come in and settle that matter for the individual, and then they step back out once it's settled. So those type of situations do erupt, but want to make it very clear, guardian person has no financial capabilities or no ability to sign off on anything financial when it comes to those matters for the client. You might also hear the term emergency guardian, and I wanted to also highlight the difference between regular guardian and emergency guardian, because we get calls all the time about saying, we need you to step in as an emergency guardian, and they don't understand what that means in legal terms. An emergency guardian, from the court's point of view, is brought in for significant issues like abuse, neglect, significant risk of harm of an individual where their life is in jeopardy, or significant medical complications of an individual where now decisions need to be made that are life-threatening, i.e. someone's on a vent and we need someone to come in and make those decisions because the individual cannot make them themselves. Emergency guardianship is only meant for 72 hours. It's designed to step in, address the emergency, and step back out. It's not designed to be a long-term fix. Emergency guardianship can be expanded to up to 30 days, depending on what the situation is, but doesn't typically get expanded beyond that because statute prohibits it from it. Now, I'm going to say very honestly, some courts take that stipulations loosely. So depending on which courts you deal with, you might end up having a case that does go beyond that 30-day mark. It's left to the judge. If the judge wants to issue that order, so be it. I'm not there to tell them how to do their job. But the statute does clearly state, it can only go up to an additional 30 days. Those are kind of the main areas of guardianship. There's a number of other terms you may hear: successor guardians, interim guardians, those type of things. They're really just a variation of what the main three I just talked about are. They're just different terms that the courts use to basically identify slight distinctions in the guardianships that they process. But overarching, those are the three main guardianships types and kind of what their roles are. I had mentioned before at the beginning of this a term called support decision making. We're constantly on our end looking for alternatives to guardianship for individuals if that can be found. That includes individuals right now that are under guardianship. If we think a less restrictive option can support the individual, then we'll work with the team to make that happen and maybe restore the individual to competency so they no longer need a guardian. That's ultimately, the goal I would love to have for all my clients, but I'm very realistic that not everybody that comes to AFSCME is going to end up being restored. That being said, on the front end, if we can work with the teams to find less restrictive supports and alternatives to guardianship for individuals, and that's something we definitely embrace. Power of attorneys are a great solution, especially for family members involved, whether that is medical or financial power of attorneys. They are not the end all be all to everything. There are limitations with power of attorneys, and I do often hear of situations where family members, meaning well, will misuse a power of attorney to try to make decisions when an individual is fully capable of making a decision at that moment. A power of attorney is designed for an individual to step in when an individual is lacking that capacity in the moment to make the decision, i.e. they're hospitalized and they're sedated and they can't not make the decision on their own because they are sedated, or they're indisposed for whatever reason, and for financial reasons that someone has to go to the bank and talk on their behalf. It's not designed as a carte blanche. I have medical power of attorney, which means you have to tell me everything under the sun and I have the right to access everything. It is literally designed for when there's emergencies and unexpected situations come up. It gives someone that authority to act on your behalf. So power of attorneys are great, but they're not end all be all in some cases. One of the things right now going on at the State House, which I'm not sure if you guys are aware, hopefully a number of you are, there's legislation at the State House that is very much trying to enact supported decision-making and creating unified and legal terms to embrace it and make it law. For those of you that are not aware, supported decision-making is basically, I'm going to simplify here, a glorified advocate for an individual. It is someone that the individual has identified that can help them understand situations, that can be a sounding board for them, and that can help them navigate complex situations so they can make their own decisions. Supported decision makers would not make decisions on behalf of the individual. They're there just to help basically interpret situations for the client so they can understand it better to make their own decisions. I think we all use this in our day-to-day life now. We all have sounding boards in our life when situations erupt. It's no different. The difference is that our individuals oftentimes don't have or have consistent non-provider related service entities that can do this and in a neutral way. So putting it into terms and in a legal way where an individual can identify and legally appoint a support decision maker, it oftentimes will help non-DD professionals as well as DD professionals understand who that person will go to when they have a problem. Now, AFSCME does support decision-making. We have for years. We have embraced it completely, and we do offer what we're calling targeted decision-making on our end. As much as AFSCME would love to be able to do support decision-making, which is usually a non-ending or a time-limited scope where an individual stays in someone's life and is there for whatever may come and go, we don't have the capacity to do it. We're a nonprofit agency. Our resources are, limited, and so we do have limitations there. But we do offer what we're calling targeted decision-making, which is a situational-based support for individuals that may need some help navigating systems. A good example of when this has occurred for us is when exit waivers are being issued for clients. And we have a client who's fully capable of maybe making their own decision, but they just don't understand the nuances of how to do a provider interview, what kind of questions maybe they should ask, you know, how to navigate and what to look for when you're looking at housing, you know, when you're going to move. And so we've stepped in those cases for, 2, 3, 4 months to help individuals navigate that world. And then they ultimately make their own decisions, and they're completely able to act independently just with a little extra support. We've also done it for individuals that have complex medical situations going on, where the doctor is not necessarily saying they can't provide their own consent, but the team is worried that maybe they're not completely understanding the complexities of the decision they're facing. And so we've been asked to step in those cases and just kind of be there as kind of a sounding board for that client, and to help them maybe consider things that they hadn't considered, and maybe consider asking questions of the doctor that they hadn't even thought of, or maybe the team hadn't thought of. And so we've done those situations as well. The idea is, as we come in, we help the individual through a specific situation, and we'd step back out. And it helps negate the need for a guardianship, because otherwise, oftentimes in this kind of situations, in the past, we'd get calls and say, we have this situation, this individual can't make the decision, they're really struggling with it, they need a guardian. And then the individual's then stuck indefinitely with a guardian, and that's never in anyone's best interest if it can be avoided. So, let's see. I don't think if there's anything else here. There are a number of other alternatives to guardianships out there. They are not as, I'm going to say, user-friendly as a power of attorney or supported or targeted decision-making is. And oftentimes it involves protection orders and other legal avenues. It does avoid guardianship, and it is short-term outcomes. So if you do feel like there's support decision-making or power of attorney is not necessarily the best path, but guardianship isn't either, feel free to reach out. I'm happy to brainstorm with you on the alternatives, whether it's, court-ordered mental health treatment for an individual, or, probated health compliance, or, a variety of other protective orders and avenues that can be pursued. They get very nuanced, so I'm not going to go into it here, but if you do have situations where you feel that you have a lack of support, or you think, guardianship may not be the best path, but you're not really sure how to support an individual, especially those that have real complex needs, those other options are usually those best served for those dually diagnosed, mental health-based individuals. And I just saw a question here. There is no fee for APSE for consultation or anything like that. APSE is a complete nonprofit. We do offer services completely free of charge. Our funding, just so you guys know, comes mainly from the General Resource Fund from the state, but also Medicaid Title 20. So we have a combination of both those billings. We do not charge for client services of guardianship. For those of you that are on the call that are familiar with APSE, have known APSE for years, we'll be glad to hear that we no longer have a waiting list for service. We had a waiting list for service in place from 2010, and so about 2019, we started slowly dissolving it. We are down to 16 individuals on our wait list statewide, and they are actively being brought off the wait list for service. Which is huge, because I think my region alone had close to, 500-600 individuals maybe on it, just in my region alone at one point in time during the waiting list era. So for us to have that dissolved is massive. I know we're all very happy about that. So we are taking clients for service. We are looking at individuals that have an immediate need for service, and whether or not, if there's not an immediate need, then we may not accept them for service. So an immediate need on our end, just so you guys are aware, is something like an individual has ongoing medical issues, and they may have the doctor may say, I don't think they can understand the consent capacity, and we're not going to accept their consent for service. And maybe they have ongoing medical issues where there's massive changes. You know, an individual has been able to make their own decisions for a long time, but now they've been diagnosed with dementia, and we're beginning to see their cognitive capacity change. Guardianship may be needed. Ongoing issues where maybe they're losing a provider or losing housing and services, or maybe there's significant MUIs and abuse, neglect, exploitation concerns going on where guardianship may be needed. Or maybe there's a situation where an individual has significant behavioral issues and the team is really looking and needing restrictive measures, and they don't think the individual has the capacity to provide those consents for those services. Those are all just a few examples of cases we might take on our end. Other reasons would be a death of a current guardian. We have a lot of individuals out there with aging family members who are their acting guardian right now. We are getting a lot of referrals, I feel like, out of especially Montgomery County, where the mom or dad who was the guardian is now in a nursing home themselves and can no longer act as guardian, and so the court's calling us and asking us to take the cases. So those are all situations that might warrant us stepping in. I saw some other questions pop up. Yeah, yeah, Karen, no waiting list, woo! So if you are needing if you feel you have a client that needs a guardian, I would definitely talk with the SSA and make sure the team is all on the same page there before making a referral to us. That way, if there's alternatives that can be explored, then please do. Not that we're not happy to take on a case if it's needed, but we can avoid having to put someone under guardianship. That's always in someone's best interest. And as far as how to apply, we do have an application process. It's pretty straightforward. In fact, I'll be emailing the form to Jennifer Rice over at the county board. I just met with them yesterday, and I was going to be emailing them anyways, the form, so the county board will have access to the referral form for anybody that needs guardianship. If you also don't have access to it through the county's end, feel free to reach out to myself. I'm happy to send it to you. And then we just ask some basic demographic questions and ask for some additional collateral that supports the need for a guardian. I will say, if you are looking at AFSCE for potential guardianship, or you have an individual that needs guardianship, whether it's through AFSCE or another entity, I want to be able to highlight this is not a fast process. It's not like you reach out today or tomorrow and by the end of next week, there's a guardian in place. That's not going to ever be that fast. We're dealing with systems here, unfortunately. So on our end, when we get the referral collateral, my reps would go out and meet an individual, the client, to make sure, we're gathering all the relevant information, make sure the client knows that their guardianship's been made, or guardianship referral's been made on their behalf, see what their thoughts are on the matter. Sometimes they're like, yeah, we're fine with you. And other times like, we don't want you. It doesn't matter if they don't want us or anything like that. We want their opinion on what's going on and what their thoughts are. And then from there, if guardianship is all in agreement that that's what's needed, then we would apply to the court. The court would then do their own investigation into the need for a guardian, and a court date would be set. And then from there, we'd have hearings on the matter. So it is not a fast process. It does take some time to get through. So please be aware of that, because I do get calls all the time about, I need a guardian, I need it like tomorrow. And unfortunately, that's not going to be executed unless it truly meets an emergency criteria with the court. So any other questions that you have for me on AFSCE or guardianship or anything like that? I did share some just handouts and resources with Kathy, which she'll share with you guys, just on like some frequently asked questions on guardianship, alternatives to guardianship. I did also send her what is called Rule 66, which are the rules of the superintendents. So just to give you a little background, all guardianships are overseen by the probate courts. So the probate courts act as superior guardian on all guardians. So if there's ever a complaint you have about a guardian, you can go to the probate court that's appointed that case and lodge a formal complaint. You have that right to do that. Anyone has that right to do that on behalf of any individual. The individual themselves has the right to lodge their own complaint and ask for a status hearing in a case. So if your individual who's under guardianship wants to talk to the judge about their guardianship, they have the right to ask for that. The judge will ultimately decide if they'll hear the case or not, but they have the right to ask. And most judges will offer about a once-a-year review of the case for the client. I don't have too many judges out there that would just blow off the clients. They're very rarely does that ever occur. But they do have the right to be heard in their cases. But all guardians are overseen by rules and regulations that are actually been issued by the Supreme Court of Ohio and the superintendent's rule. So I did go ahead and send that to Kathy as well for you guys to peruse. And it's basically all the rules and regs that a guardian has to do, everything from reporting requirements to notifications of changes of addresses to education training requirements and so on and so forth. So I wanted to share that with you guys in case you guys ever were questioning what a guardian is required to do under statute. So I wanted to send that to you guys as well. Now I will say that the Supreme Court Rule 66 is flawed. Everyone knows it's flawed, including the Supreme Court themselves, but until the legislature comes up with a unified code on guardianship, it's going to remain in place. There have been numerous talks at the State House on how to regulate guardianship and what that would look like and putting it under Ohio Revised Code versus it being under the statute under the Supreme Court. But I think we're a little ways off from any kind of final version of any kind of draft being submitted for review outside of committee. And I know our executive director and our attorney have their fingers on the pulse of that dynamic completely. So they just kind of give us, oversight of what's going on. And I'm glad that is not on my plate to deal with. Legislative changes far above my pay grade, but it does exist. And so there could be changes in the future on the rules that guardians have to abide by. So, but for now, Rule 66 is the kind of the Bible in the state of Ohio. So I did provide that for you guys as well. All right.
Thank you, Christina. That was wonderful. A lot of helpful information there. I appreciate the resources. We will definitely send those out with our meeting minutes today, along with your contact information. That way, if there are additional questions, providers can get a hold of you. So thank you so much. I am going to share my screen now. I wanted to give you all some provider updates. A lot of this information I have now for you is things shared from DODD. We encourage you always to subscribe to their email notifications to get this information. Since we only meet every other month, some of the things they share are more time sensitive, but I'm sure you all are aware, but in case you forgot, like me, that July is just around the corner, there is a second rate increase coming in July 1st. Those rates are published in the appendixes of the rules for the services. We also, for Butler County, have made a rate chart that we will share with our meeting minutes today. Again, that is just for category 7s like Butler. If you're working at other counties, they may be a different category of pay. So you are responsible as the provider when submitting your billing to put that new rate in beginning July 1. If you continue to put in the old rate, you will be paid at that lower rate. So included some links for you to be able to access those. Also the overtime rate for independent providers, those rates have not actually been released officially yet, but this is the link here where you'll be able to get those once they come out. Normally, within a month of the rate changes, we will see those. And then, of course, a good reminder for any of you doing participant-directed services, you must renegotiate your contract in order to get that new rate. That must be redone before July 1 to get that new rate for that service. Oops. Also, something coming in the near future, wanted to put, make sure you're aware of July 1. This is happening. This is what the last at least guidance that we've received. We have not received the official for sure this is happening, but they have been suggesting it will become effect July 1, is that EVV is now going to be required for residential respite and for nursing delegation. So we will, again, release more information about that as it becomes official, but subscribing to DoDD publications is really the best way to know for sure when that happens. So just wanting to make sure you have that on your radar for that. You can reach out to us in provider relations, Amy and I, if you need assistance getting that set up or have questions about it, we can direct you over to SendData to get help with that. A reminder that came out from DoDD is about delegation of healthcare tasks we wanted to share with you. So family members are authorized to administer medications with MedAdmin certification when a person with developmental disabilities resides with a family member. Paid family members who live with the person served can also support delegated tasks when there is no nursing judgment required. The outcome is reasonably predictable. Tasks are non-life threatening and do not require complex observation. So this actually, I just realized is a typo, Amy. You back me up here. It's just, this should say, or they're authorized to administer medications without MedAdmin certification. Is that correct? Yeah. Yeah, sorry about that. So without that makes more sense. I was like, that doesn't quite make sense. So family members, you administer medications when you're living with a family member without that med certification. Just a reminder, nothing has changed there. It's just a reminder about that. Delegation of healthcare tasks is specific to the person served and based on the nurse's assessment. When complex nursing tasks are performed by a paid caregiver, nursing delegation is required according to the rule. Feel free to pop any questions you have in the chat as I'm going along. Always welcome that. We were notified that the Ohio Department of Medicaid is starting their payment error rate measurement for 2025. That's just now starting. That's required by CMS. It's a program in which they are assessing ODM's payment accuracy. And so some of you as DoDD providers, because you are also a Medicaid provider, may be chosen to participate in this sample. So if you are contacted to participate, you've been selected, you are required to submit your service documentation to them. And if you do not comply with that, they could actually initiate recoupment of your payments. So we encourage you to comply with that and follow any email notifications. Again, good reminder, keep your email up to date in PNM. That's really important. That's the way that the state contacts and Medicaid contacts providers. And as a reminder as well, providers are required to maintain all records for 6 years. This is an example of when they may contact you for an audit or for this like a sample, and going back and getting those records will be required back to 6 years. Something else that we learned about, we're kind of excited about, we're kind of waiting though to hear the final rollout, how this will look for you as providers, being DoDD providers, rather than primarily a Medicaid provider. But again, just like we just heard, you are technically a Medicaid provider being under DoDD, but there are some new features that are going to be launched in PNM on June 30th. And they are supposed to improve functions for providers. So some things that you're able to do on your own in there. And we're not exactly sure. There's some trainings they're launching to be able to look at that. And we have not yet had the chance to attend those. They're just starting. But we are curious. They mentioned that they are going to be able to give providers access to financial documents. So we'll be curious to see what that means once we're able to get in there and see that. But just wanted to put that out there. If you're curious to check that out, their training dates are available here at this link. You can sign up for that and learn more about it. For those of you providing employment services, so for career planning and individual employment supports, DoDD is developing outcome-based payments. It's very exciting. This will be in addition to the service payments. And the goal behind those is to incentivize and reward providers who support our individuals to access community jobs they want and need, and to have job retention. So that's really exciting. There's more information going to be coming out about that, but wanted to make you aware that that is happening. It's been approved. So there are 3 trainings being offered right now for providers. Encourage any of you providers that are providing either one of those services to attend one of these. The link here is to register, but they're starting actually next week and then continuing through June. I'm guessing they'll have recorded materials as well once these are completed. And then in July, they're going to go even further into it. So these first 3 are just to kind of outline what this new payment system will be like, and then further detail in July. So, and that registration link has not yet been released, but so we'll provide that later. DoDD, DSP, and provider support team continues to offer monthly office hours. They're the second Wednesday of each month from 9 to 10. You don't need to register. You can just hop on. And I've attended a few of them, and they're great because you're able to ask questions. There's usually a topic for the first part of the meeting that's related to DSP and providers. And then there is time to ask questions or get support for things that you may be in need of. So I encourage you to use that if you'd like to. This next announcement is specific to providers of inclusive housing resources tenants. So not for all of you, but if you are a provider of someone that lives in an IHR home, they are seeking assistance from those providers to get feedback because they're planning a really exciting tenant event coming up later this year, and they want to make it very successful for tenants to have it to be something that they want. So they are asking for your help as providers to help your tenants, your individuals you're serving, to complete that survey. So I have the link here. We'll also email that out. There's a flyer they've shared with us. They're really hoping that they can get as much feedback as possible. So I encourage you to take a few minutes to do that with your clients. A couple of training opportunities to share with you. The first one is these monthly ones that are offered by the the Office of Compliance, DoDD's Office of Compliance. They're held monthly from 10 to 11. They have now released all of their topics for the year. So I encourage you to mark your calendar, especially if there are ones that really pertain to the services you're providing. These are very helpful. They do record them and provide handouts, but they are usually a few weeks out before they post them. So you can go to the Office of Compliance page on DoDD's website to register for these as the dates get close. They usually don't have a registration link until just a few weeks out from each date. Another training to be aware of, we announced this last time, but this last one is coming up here in June. It's an in-person resilience-based de-escalation training. This is for providers that are working with youth with complex needs and developmental disabilities. There is a registration link that is being held in Warren County, and that is the last one that's in our area. It's an all-day training. That is all I had for today, all of our trainings and updates. Again, just making you aware of our upcoming meetings. We love that so many of you are here today. I think we had a new record of number of providers on the call today, so we really appreciate you coming. Hope that you'll join us in July 17th. Would love to see you all. As always, reach out to Amy and I if you ever have questions or need support. We're here to support you. We'll take time too. We'll stay on if you have any questions for us. All right, so we do have a few questions in the chat. The process for the participant directed services, renegotiating that, you will contact the SSA of the individual that you're serving, and they can provide you with that document. There is a form that you will fill out and is signed by the individual as well. Oh, Amy, sorry, I see that you've answered that now. I apologize. Amy's on top of it, but maybe that'll help somebody else too if you didn't see the chat. Just if there's anything else that might help the group. All right, I guess that everything's covered there. Anybody else have any?
I have a question.
Sure.
Okay. My question is, I am the provider for my brother and I'm his sister and his guardian also. Periodically, I have other siblings that want to keep him for like 2 or 3 days, and I know that I'm not compensated for those days. But my question is, if they were to keep him and something happened, let's say usually if I'm keeping him and something happens, and it may be a MUI or a UI. What is the protocol for that if something happens and he's with them? I mean, do I gather the information, what happened from them, or what's the protocol for that?
All right. Hi, Jackie. It's good to
Hi.
have you here. So I missed it. So is the person that's providing the care not a paid provider? They're just a family friend or family member?
Just a family member.
Right, right. So, that MUI rule, the reporting and the documentation applies when services are being provided, Medicaid services are being provided. So you would not be required to be documenting that during that time if you are not going to be billing and providing services.
Okay. All right, thank you.
Yeah, you're welcome. All right, well, I'm going to stop recording, but feel free to.
Can I please ask a question closer to what she just asked?
Sure, of course.
Now the person has come back to her with a big bruise on the leg, and now she's providing paid services. She has seen the big bruise. Will she keep quiet or she will write incident report?
Yes, so the person was with a provider and got a bruise and now is home.
The person was with her sister. Her sister is not a provider, it's just a family member. The individual sustained a big bruise on the leg. Now, the individual has come back to the paid provider. The paid provider has seen a big bruise on the individual's leg. Will the paid provider write an incident report or not?
I would encourage you to contact the SSA and then they can advise you whether you should report that to the MUI department. Always when you have questions like that, I would reach out and report. It's better to check things out, document than to not.
Hey, Kathy, this is Tracy. I would say in that situation when someone's, with an unpaid provider and then they come back into your care and as a paid provider, especially in, when she's saying she's also the guardian, that I would report that. It's an injury of unknown origin as far as we would be concerned. That's how I would look at it as the SSA is. I would want to know about that because then an investigation could be as to what happened, why is this person bruised, and it might be just lead to further discussion of is that necessarily a safe environment for that person to be in the future. So I think it definitely should be reported.
Thank you.
Thank you, Tracy.
And Kathy, we had something in the chat about, this is a great question, actually, it's been brought up a lot lately, that it's hard to find clients. So we have seen a really big uptick in applications in our portal. If you guys are registered in there and actively using that, we're seeing some service requests with 60, 70 plus applicants of providers applying. So I think it's just and that wasn't the case maybe a year ago. So it's really been a big uptick in people applying, which is good that we have folks interested and willing to meet those needs. But then I know it's hard on your guys' side when there's that many people applying. So just be patient. I encourage you guys to keep applying. Just try to be as specific as you can when you're applying in that cover letter box as to why you think you'd be a great fit to work with that person. But overall, we are seeing a big uptick in provider applicants, and that might be why you guys are seeing, the lack of responses that you used to in the past.